My name is Ed Hunter and I'm an associate in the UK Labour and Employment team. Today I'll be giving you an overview of how to make changes to employees' terms and conditions. During the employment relationship, employees' terms are bound to change in a number of ways, for example where an employee is promoted or receives a pay rise. Many changes will not affect the terms of the contract. For example, it is common practice for employers to state that certain benefits and policies are non-contractual. This will generally allow the employer to make changes as and when required, provided that A, the policy or benefit has not become contractual through custom and practice, and B, the employer does not impose the change in a discriminatory manner or a way that breaches the implied term of mutual trust and confidence. For the rest of this podcast, I will be focusing on changes to terms and conditions which do form part of the contract. Remember, contractual terms are not limited to those set out in the written contract or offer letter. You will also need to consider any terms which have been separately agreed between the parties, either orally or in writing, terms which are implied into the contract, for example through custom and practice, and any terms which are incorporated by statute or through collective agreements. As with changes to non-contractual practices and policies, in many cases, changes to contractual terms will not be controversial. Difficulties are more likely to arise where employers wish to impose changes that may be detrimental to the employee. This could be discrete changes to specific terms, such as pay rates, job duties and restrictive covenants, or a series of changes which form part of a wider contract harmonisation exercise. The options available to employers depend on whether or not the change being introduced is authorised by the contract of employment. The first step, therefore, is to look at the contract. The terms of the contract may allow for the change to be made in one of two ways. First, the term which the employer is seeking to vary could be drafted in a way which is sufficiently wide to accommodate the change without any actual variation needing to be made. For example, if you are looking to allocate additional duties to an employee's role, it might be possible to interpret their current job description as already covering the new duties. However, when considering the existing provision, it's important to remember that the courts will generally resolve any ambiguity in the drafting in favour of the employee. Therefore, careful consideration should be given to the true scope of the provision in question before any changes are introduced on this basis. The second way in which the contract may permit a contractual variation is if it either contains an express right to make a specific change to a particular term or a general power to vary the terms of the contract. These types of provisions are known as flexibility clauses. A word of warning here, the courts are particularly wary of any clauses which seek to give the employer carte blanche to make changes to terms and conditions and will rarely enforce them. The reason for this is that they are seen to go against the general principle that any contractual changes must be mutually agreed. Even specific flexibility clauses will be given a narrow interpretation, and they must be drafted in an extremely clear and precise way to have any prospect of being enforceable. Additionally, the effect of flexibility clauses may be limited by certain implied terms of the employment contract, for example, the obligation to act reasonably when exercising the clause. These limitations were illustrated recently in the case of Norman and others against the National Audit Office. Here, the National Audit Office sought to unilaterally impose changes to employees' entitlements to contractual sick pay and annual leave. It did so in reliance on a clause in the employees' contracts which stated that terms and conditions were subject to amendment and that staff would be notified of any changes. The tribunal originally held that the clause gave the National Audit Office a right of unilateral variation, and the changes had therefore been validly implemented. However, this decision was subsequently overturned by the Employment Appeal Tribunal. It found that the provision stating that the terms were subject to amendment was nowhere near the standard of being clear and unambiguous that was required for such a clause to be enforceable. In particular, the clause didn't actually state which party to the contract could amend its terms, or what the mechanism for doing so was. Therefore, there had not been a valid amendment of the employee's terms. This case illustrates the extent to which general flexibility clauses will be particularly scrutinised by the courts, and in practice these clauses should only be relied upon for reasonable or minor alterations. So as you can see, whilst the contract may offer a contractual right to vary terms without the employee's agreement, it's important to examine the relevant provisions closely and be aware of their potential limitations. Where the proposed changes are not authorised by the contract, an employer has three options open to it. The first option is to seek to obtain the employee's consent to the changes, either from the employee directly or through a binding collective agreement. This is generally the most straightforward option for employers. The employee can give their consent orally or in writing, but it's best to get a written record of the variation in case there is a dispute about what was agreed later down the line. This is particularly important where the amendment involves a change in remuneration, as this could give rise to a deduction from wages claim. In any event, written confirmation of any changes to particulars which must be included in the written statement of terms and conditions under Section 1 of the Employment Rights Act 1996 needs to be provided within 1 month. There is also a requirement under general contract law for the employee to receive some sort of benefit or consideration in return for accepting the change. In many cases, the employee's continued employment will constitute sufficient consideration. However, there can be difficulties where the change does not have an immediate effect, for example where restrictive covenants or entitlements on termination are altered. In such cases, it will usually be necessary to offer some other form of benefit to the employee in consideration for the change, for example by tying it to a pay rise. The second option for varying the contract is to unilaterally impose the change on the employee and rely on the employee's implied agreement. In doing so, the employer will be in breach of contract and the previous terms will technically remain in place. The employee can respond to the breach in one of three ways. First, they can comply with the new terms but work under protest and bring a claim for breach of contract or, where there is a reduction in pay, unlawful deduction from wages. Second, if the breach is fundamental and goes to the root of the contract, the employee can resign and bring a claim for constructive dismissal. Third, the employee may be able to refuse to work under the new terms. For example, if their hours have changed, they could continue to work under their previous hours. This is therefore a risky approach. From the employer's perspective, this strategy is more likely to be effective where the change being imposed has an immediate practical impact, such as a pay cut or change in work location. In that situation, if the employee continues to work without objection, the employer can argue that they have impliedly consented to the change. This argument is unlikely to hold much weight if the change doesn't have any immediate impact on the employee. The third option for making changes to employees' terms is to terminate the contract and offer to re-engage the employee on new terms. In view of the risks associated with imposing changes unilaterally, this may be the best option where the employee refuses to agree to the variation. This approach is, of course, not without risk. It exposes the employer to claims for unfair dismissal and, unless the employee's notice entitlements are honoured, wrongful dismissal. However, provided that there is a good business reason for the change, an employee's refusal to agree to the variation will usually amount to some other substantial reason for unfair dismissal purposes. As with other categories of fair dismissal, the employer will need to act reasonably and follow a fair procedure to avoid liability for unfair dismissal. An important point to note is that where this approach is being followed in relation to 20 or more employees, collective consultation obligations are likely to arise. The consequence of failing to comply with these obligations is severe, as an employment tribunal can award compensation of up to 90 days gross pay per affected employee. Clearly, this risk will need to be considered at the outset of any contractual variation exercise. Employers will also need to bear in mind any additional consultation obligations, for example, in an applicable collective bargaining agreement or an information and consultation agreement. Finally, whilst we've been focusing on the contractual implications of imposing changes, there may be additional considerations under UK legislation, for example in relation to changes to pension terms or variations made in connection with a TUPE transfer. As always, advice should be sought before you embark on any variation exercise. So that's been a brief run through of the options open to employers when looking to make changes to terms and conditions. As I mentioned, Where the contract doesn't allow for the change to be made, the simplest option is usually to seek employees' consent to the changes beforehand. From an employee engagement perspective, it can be helpful to offer incentives in return for the variation, and also to consider whether the changes could be implemented over a phased period, which might make them more palatable. This is essentially a selling exercise, and in practice, the way that the changes are presented to employees is likely to be highly significant. That brings us to the end of this podcast. I hope you have found it useful, and please do not hesitate to contact us if we can be of any assistance.